The Law on Public Officers and Election Law by Hector S. De Leon and Hector M. De Leon Jr. 8th edition, 2014. The Law on Public Officers, Part 1, Chapter 1. Definitions, distinctions, and classifications. Meaning of office. An office may be defined to be that position or function by virtue of which a person has some employment in the affairs of another, whether the incumbent is elected by appointment or by election, and whether he is appointed during the pleasure of the appointing power or for a fixed term. Meaning of public office. A public office is the right, authority, and duty created and conferred by law, by which, for a given period, either fixed by law or enduring at the pleasure of the appointing power, an individual is invested with some portion of the sovereign functions of the government to be exercised by him for the benefit of the public. In its broad sense, a public office is a charge, a station, or employment conferred by appointment or election by a government. Purpose and nature of public offices. The purpose and nature of public office is grounded on it being a public trust. Number 1, public offices are created for effecting the end for which government has been instituted, which is the common good, and not for the profit, honor, or private interest of any person, family, or class of persons. Number 2, a public office is a public trust created in the interests and for the benefit of the people and belongs to them. The nature of a public office is inconsistent with either a property or contract right. It is conceived of as a responsibility and not a right. As recipients of public trusts, public officers are under obligation to discharge their duties faithfully and to the best of their ability. Public office as a public trust. Number 1, holders regarded as public servants. Since an incumbent of a public office is invested with certain powers and charged with certain duties pertinent to sovereignty, the powers so delegated to the officer are held in trust for the people and are to be exercised in behalf of the government or of all citizens who may need the intervention of the officer. Such trust extends to all matters within the range of duties pertaining to the office. In other words, public officers are but the servants of the people and not their rulers. Number 2, holders subject to highest standards of accountability and service. Our Constitution lays stress on the above concept of public office by making a categorical declaration thereof. Public office is a public trust. Public officers and employees must at all times be accountable to the people serve them with utmost responsibility, integrity, loyalty, and efficiency, act with patriotism and justice, and lead modest lives. 2a. A public official or employee, therefore, occupies a very delicate position which exacts from him certain standards which generally are not demanded from or required of ordinary citizens. He occupies the office to render service to the people and not as a means to promote his personal interests. The only justification for his continuance in such office is his ability to advance public ends and contribute to the public welfare. 2b. The Code of Conduct and Ethical Standards for Public Officials additionally provides that every public servant shall at all times uphold public interest over his or her personal interests. By the very nature of their duties and responsibilities, public servants must faithfully adhere to, hold sacred, and render inviolate the constitutional principle that a public office is a public trust. When they take their oath of office, they bind themselves to perform the duties of their office faithfully and to use reasonable skill and diligence and to act primarily for the benefit of the public. Public office, not property. Number 1. Holder subject to removal or suspension according to law. The constitutional principle of a public office as a public trust precludes any proprietary claim to public office. A public office is not the property of the office holder within the meaning and contemplation of the due process requirements of the Constitution. This means that public office is not property in the sense that an officer is not denied due process of law by the abolition of his office before the expiration of his term or by his removal or suspension according to law, or by the passage of a statute limiting or reducing his compensation, and that an officer has no property right in the books and papers pertaining to his office. Number 2. Holder without vested right in any public office. No one, therefore, has any private right of property or vested right in any public office he holds, much less a vested right to an expectancy of holding a public office. At least, as against the public interest, the fact that the Constitution throws a mantle of protection around a public officer, such as a limitation on the power of the legislature to abolish the office or diminish the salary during the incumbent's term, does not change the character of the office or make it property. Excepting constitutional offices which provide for special immunity as regards salary and tenure, no one can be said to have any vested right to an office or its salary, let alone an absolute right to it. It is only when salary has already been earned or accrued that said salary becomes private property and entitled to the protection of dual process. Number 3, holder's right in nature of privilege entitled to protection. It does not follow, however, that a public officer has absolutely no financial property interests which may be protected by a court against wrongful interference by others, or that he may be deprived of office without hearing when the right to have it terminated is limited to specified cause. The incumbent's right to office is recognized as a privilege entitled to the protection of the law, and an office may be considered as property within the protection of the due process guarantee of the Constitution in controversies relating to the question as to which of two persons is entitled thereto. When the dispute concerns one's constitutional right to security of tenure, public office is deemed analogous to property in a limited sense. Hence, the right to due process could rightfully be invoked. Number 4. Holder's right personal to him. Public office is a personal to the incumbent thereof or appointee thereto. In this sense, it is not property which passes to his heirs upon death. It cannot be inherited. Thus, the heirs of the protestee in an election contest may no longer prosecute the latter's counterclaim for damages against the Protestant, for that was extinguished when death terminated the deceased protestee's right to occupy the contested office. Illustrative case. If subsequent law changes the tenure of offices of justices and auxiliary justices of the peace. Facts. S was appointed Justice of the Peace on January 21st, 1907. He continuously occupied this position until, having turned 65 years old, he was ordered by the Secretary of Justice to vacate the office on July 1st, 1924. Since that date, N, the Auxiliary Justice of the Peace, has acted as a Justice of the Peace for the municipality. S instituted quo warranto proceedings to inquire into N's right to occupy said office, to oust the latter therefrom, and to procure reinstatement as Justice of the Peace. Issue whether the provision of Act Number 3107 stating that Justices of the Peace and Auxiliary Justices of the Peace shall be appointed to serve until they reach the age of 65 should be given retroactive or prospective effect. Held. 1. Law should be given prospective effect only. Act Number 3107 amended Section 203 of the Administrative Code by adding at the end thereof the following proviso. Provided that Justices of the Peace and Auxiliary Justices of the Peace shall be appointed to serve until they have reached the age of 65 years. However, Section 206 of the Administrative Code entitled Tenure of Office and reading, a Justice of the Peace having the requisite legal qualifications shall hold office during good behavior unless his office be lawfully abolished or merged into the jurisdiction of some other justice, was left unchanged by Act Number 3107. A sound canon of statutory construction is that a statute operates prospectively only and never retroactively unless the legislative intent to the contrary is made manifest either by the express terms of the statute or by necessary implication. Number 2. Intention to disturb right to office should be clear. Though there is no vested right in an office which may not be disturbed by legislation, yet the incumbent has, in a sense, a right to his office. If the right is to be taken away by a statute, the terms should be clear in which the purpose is stated. Segovia versus Noel, number 47. Note, The case at bar must be distinguished from the case of Chanco versus Imperial. In that case, the question was as to the validity of Section 7 of Act Number 2347, which not only provided that justice of the courts of first instance shall serve until they reach the age of 65 years, but further provided that the present judges of the courts of first instance shall vacate their positions on the taking effect of this act, and the Governor General, with the advice and consent of the Philippine Commission, shall make new appointments for judges of court of first instance. The intention of the legislature to vacate the office was clearly expressed. In Segovia versus Noel, such intention is not expressed at all. Under the Constitution, the members of the judiciary enjoy security of tenure during good behavior. Congress is prohibited from passing a law reorganizing the judiciary when it undermines the security of tenure. Public office, not a contract. The right of an incumbent of an office does not depend on any contract in the sense of an arrangement or bargain between him and the public. 1. Creates no contractual relation between holder and the public. A public office is not a contract, nor the same thing as a contract. And an appointment or election to a public office does not establish a contractual relation between the person appointed or elected and the public. The incumbent is not under contract so as to withdraw his tenure, salary, and the like from the control of the legislature or to preclude the legislature from abolishing the office. Generally speaking, the nature of the relation of a public officer to the public is inconsistent with either a property or a contract right. Number 2, exist by virtue of some law. The right to hold a public office under our political system, therefore, is not a natural right. It exists when it exists at all, only because and by virtue of some law expressly or impliedly creating and conferring it. Number 3, generally entitles holder to compensation. While public office is not usually regarded as a contract, a public officer is entitled to the compensation for the performance of his public duties when the law attaches it to the office. If no salary is provided by law for an office, the incumbent is presumed to have accepted it without pay and he cannot recover anything for service rendered by him. The salary is a mere incident and forms no part of the office. It is not a necessary criterion for determining the nature of the position. Public office and public contract distinguished. One contracting with the government is, in no just and proper sense, an officer of the government. There are points of difference between a public office and a public contract. 1. As to creation. A public office is a creation incident of sovereignty, while contract originates from the will of the contracting parties, subject to the limitations imposed by law. Number 2. As to object. A public office has for its object the carrying out of sovereign as well as governmental functions affecting even persons not bound by contract, while a contract imposes obligations only upon persons who enter the same. Number 3. As to subject matter and scope. A public office embraces the idea of tenure, duration, and continuity, and the duties connected therewith are generally continuing and permanent. A contract, on the other hand, is almost always limited in its duration and specific in its objects. Its terms define and limit the rights and obligations of the parties, and neither may depart therefrom without the consent of the other. The fact that the duties of a particular position or governmental function do not depend on a contract is itself one of the criteria of a public office. Public office and a public employment distinguished. Number 1. Key considerations. Public office is, in a sense, an employment and is very often referred to as such. Although every public office may be an employment, every public employment is not an office. A man may certainly be employed under a contract, express or implied, to perform a service without becoming an officer. It is the nature of the office, the powers wielded, and the responsibilities carried out that are the key considerations. The delegation to the office holder of some of the sovereign functions of government is the most important characteristic which distinguishes a public office from employment or contract. Number 2, manner of creation and nature of duties. Generally, a position is a public office when it is created by law, with duties cast upon the incumbent which involve the exercise of some portion of the sovereign power, and in the performance of which the public is concerned. While a public employment is a position which lacks one or more of the foregoing elements, where therefore the position is created not by force of law but by contract of employment, it does not rise to the dignity of an office. A public office, as has been stated, is not a contract, and the right of an incumbent to the position does not rest upon any agreement between the government and himself. The same is also true where the duties connected with the position do not involve an exercise of some portion of the sovereign power. Essential elements of a public office. They are as follows. 1. It is created by the Constitution or by law or by some body or agency to which the power to create the office has been delegated. 2. It must be invested with an authority to exercise some portion of the sovereign power of the state to be exercised for public interests. 3. Its powers and functions are defined by the Constitution or by law or through legislative authority. 4. The duties pertaining thereto are performed independently without control of a superior power other than law, unless they are those of an inferior or subordinate officer, created or authorized by the legislature and placed by it under the general control of a superior officer or body. And 5. It is continuing and permanent in nature and not occasional or intermittent. Delegation of sovereign functions is essential in the public office. An investment in an individual of some portions of the sovereign functions of the government to be exercised by him for the benefit of the public makes one a public officer. Compensation is not an essential element of public office. At most, it is merely incidental to the public office. Creation of public office. Number 1. Generally, An office is created by some constitutional or statutory provision or by authority conferred by it. Number 2, by Congress. Except for such offices as are created by the Constitution, the creation of public offices is primarily a legislative function. In so far as the legislative power is not restricted by constitutional provisions, it is supreme and the legislature may decide for itself what offices are suitable, necessary, or convenient. 2A. When in the exigencies of government, it is necessary to create and define new duties. The legislative department has the discretion to determine whether additional offices shall be created or whether these duties shall be attached to and become ex officio duties of existing offices. 2B. An office created by the legislature is wholly within the power of that body, and it may prescribe the mode of filling the office and the powers and duties of the incumbent, and if it sees fit, abolish the office. Number 3, by the president. As far as bureaus, agencies, or offices in the executive department are concerned, the president's power of control may justify him to inactivate the functions of a particular office, or certain laws may grant him the broad authority to carry out reorganization measures. In particular, under the Administrative Code of 1987, the President, subject to the policy of the Executive Office and order to achieve simplicity, economy, and efficiency, shall have the continuing authority to reorganize the administrative structure of the office of the President. For this reason, he may transfer the functions of the other departments or agencies to the office of the President. Modification or abolition of public offices. The power to create an office generally includes the power to modify or abolish it, and the power to create and abolish offices carries with it the power to fix the number of positions in the salaries or emoluments of the holders thereof, and to provide funds from the offices created. The power is inherently legislative. Number 1, offices created by Congress. Where the office is of legislative creation, Congress may, unless prohibited by the Constitution, control, modify, or abolish it whenever such course may seem necessary, expedient, or conducive to the public good. The power extends to consolidation of offices, resulting in abolishing one and attaching its powers and duties to another. Public offices are created to meet the needs of the people, and when such need ceases to exist, there is no obligation or necessity to continue a useless office. The determination that a position should be abolished for reasons of efficiency and economy is solely within the judgment of the governing authority in whom the power to eliminate the office is vested. Number 2, offices created by the Constitution. Constitutional offices may be modified or abolished by the people through a constitutional provision. Such offices are beyond the power of the legislature to alter or discontinue. Congress cannot modify or abolish constitutional offices indirectly, such as by taking away the duties and emoluments of the office, thereby, in effect, abolishing it, or by consolidating the office with another office. However, the mere mention of an office in the Constitution does not necessarily endow the office with constitutional status which prevents its abolition by Congress. Exercise of sovereign powers and functions. 1. One of the most important criteria of public office. There is implied in every public office an authority to exercise some portion of the sovereign power of the state in making, executing, or applying the law. This investment of the incumbent with some of the functions pertinent to sovereignty is one of the most important criteria of public office. 2. Authority conferred by law. Constitutionally, the term public office implies said authority to exercise some portion of the sovereign power, either by enacting laws, executing them, or adjudicating controversies in the exercise of power and authority bestowed by law. Unless the powers conferred are of this nature, the position is not a public office. Number three, extent of authority not material. The fact that the authority of the incumbent is confined to narrow limits is not material. It is the duties of his office which make him a public officer and not the extent of his authority. Number 4, presumption of regularity of official acts. Public officers enjoy the presumption of regularity in the exercise of their functions. Thus, absent clear and convincing proof, the bare allegation that a public officer acted with malice or prejudice cannot be sustained. As a general rule, official acts enjoy the presumption of regularity, and the presumption may be overthrown only by evidence to the contrary. When an act is official, a presumption of regularity exists because of the assumption that the law tells the official what his duties are and that he discharged these duties accordingly. But not all acts of public officers are official acts. For example, acts specified by law as an official duty or as a function attached to a public position, and the presumption does not apply when an official's acts are not within the duties specified by law, particularly when his acts properly pertain or belong to another entity, agency, or public official. Tenure and duration. Number 1, existence of definite tenure not material. Public office embraces the idea of tenure and duration. The duration of tenure need not be for a fixed period, but may be at the pleasure of the appointing power. One may be nonetheless a public officer because his term is not definitely established. And the absence of a definite tenure does not necessarily preclude a position or employment from constituting a public office. 2. Continuance of office holder not material. At the same time, the element of continuance, for example, the duties attached to the position continue though the office holder be changed, cannot be considered indispensable. Number 3, permanence of office not material. If the other elements are present, it can make no difference whether there can be but one actor or a series of acts to be done, whether the office expires as soon as the one act is done or is to be held for years or during good behavior. However, something more permanent than a single transaction or transitory act is commonly required to make the position a public office. Meaning of officer, public officer, employee. 1. The term officer is one inseparably connected with an office, and so it may be said that one who holds a public office, as that term is herein before defined is a public officer. Where there is no office, there can be no public officer. A public officer is such an officer as is required by law to be elected or appointed, who has a designation or title given to him by law, and who exercises functions concerning the public assigned to him by law. Number 2, under the Administrative Code of 1987, an employee, when used with reference to a person in the public service, includes any person in the service of the government or any of its agencies, divisions, subdivisions, or instrumentalities. This definition includes an officer as defined below. Letter A. An officer, as distinguished from the clerk or employee, refers to a person whose duties, not being of a clerical or manual nature, involves the exercise of discretion in the performance of the functions of the government. B. When used with reference to a person having authority to do a particular act or perform a particular function in the exercise of government power, officer includes any government employee, agent, or body having authority to do the act or exercise that function. Officer and employee distinguished. Number 1, in the law of public officer, an officer is distinguished from an employee in the greater importance, dignity, and independence of his position, being required to take an official oath and perhaps give an official bond, and in the liability to be called to account as a public offender for misfeasance or nonfeasance in office. Moreover, a public officer must be invested by law with a portion of the sovereignty of the state and authorized to exercise functions either of an executive, legislative, or juridical character. However, the fact that the position is a subordinate one and that its holder may be accountable to a superior does not prevent it from being an office or the incumbent, an officer as distinguished from a mere employee. A subordinate or inferior is nonetheless an officer. A degree of responsibility for results rests upon a public officer that does not attach to a mere employee. Number 2, under the revised penal code, any person who, by direct provision of law, popular election, or appointment by competent authority, takes part in the performance of public functions in the government of the Philippines, or performs in said government, or in any of its branches, public duties as an employee, agent, or subordinate official, or of any rank or class is deemed a public officer. The definition eliminates the standard distinction between officer and employee in the law of public officers. It is also quite comprehensive, embracing as it does every public servant from the highest to the lowest. Meaning of public official. A public official has been defined as an officer of the government itself, as distinguished from the officers and employees of instrumentalities of government. Hence, the duly authorized acts of the former are those of the government, unlike those of government instrumentality, which may have a personality of its own, separate and distinct from that of the government as such. The term is ordinarily used synonymously with public officer. Classification of public offices or public officers. Public offices and the public officers occupying them may be classified as follows. 1. As to nature of functions. A. Civil office. It covers any kind of a public office, whether executive, legislative, or judicial. However, it does not include military offices, and the term civil office and military office are used in the law in contradiction to each other. And B. Military office. It includes all offices in the armed forces which solely involve military functions. 2. As to creation. A. Constitutional office. It is one created by Constitution. And B. Statutory office. It is one created by statute and over which Congress has full control. Number 3. As to the department of government to which it belongs. A. Legislative office. It is one charged with functions involving mainly the enactment of laws. B. Executive office. It is one charged with functions involving mainly the execution or administration of laws. And C. Judicial office. It is one charged with the functions connected with the adjudication of actual justiciable controversies in the interpretation of laws. 4. As to branch of government served. A. National office. It includes any office in the national or central government, as distinguished from the different forms of local governments. And B. Local office. It includes any office in the political subdivisions of the Philippines, whether pertaining to the autonomous regions, the provinces, cities, municipalities, barangays, and other forms of local government. 5. As to whether exercise of discretion is required. A. Quasi-judicial office. It includes any office other than courts of justice whose officers are charged with functions that are not strictly judicial but require the exercise of discretion or judgment. And B. Ministerial office. It includes any office whose officers are charged with the duty to execute the mandates lawfully issued of their superior. 6. As to compensation. A. Lucrative office, office of profit, or office coupled with an interest. It includes any office to which salary, compensation, or fees are attached. The amount of salary is supposed to be an adequate compensation and fixes the character of the office as a lucrative one. And B. Honorary office. It is one to which no compensation is attached and is supposed to be accepted merely for the public good. If the duties and functions require the exercise of discretion, judgment, experience, and skill, it is said to be an office of trust. It is not necessary that the officer should have the handling of public money or property, or the care and oversight of some pecuniary interests of the government. Salary or compensation may or may not be attached to the office to make it one of trust. According to the legality of title to the office, a public officer is either de jure or de facto.